The Government of India has now notified the Public Examinations Act, which provides stringent punishment on paper leaks and other forms of cheating during public examinations. This development comes as there is a raging debate and outrage over cancellation of 2 exams and the NEET exam scams. Over the next 30 minutes, we are going to dive deep into the punishments, the offences, the logic and the big takeaways of this crucial bill. And let's start with the big 5 punishments that form the basis of this anti-exam act. And here's a look at what are these important criteria that were kept in mind by the Government of India in bringing out this act against leakage of exam papers. Big takeaway number 1, action against person who has resorted to unfair means, and this punishment is going to be for 3 to 5 years in jail and fine up to 10 lakh rupees for that individual. There has been action that has been taken against service providers, and the punishment that is going to be given to these service providers would be a fine of up to 1 crore rupees, recovery of cost of examination. Big takeaway number 3, where action against directors, senior management and persons if in charge will also be taken, where they will be punished for a period of 3 to 10 years in jail and a fine of 1 crore rupees as well for the directors and the senior management and the persons who are in charge. Big takeaway number 4, action against the person or the group that is involved in the organized crime. They will be imprisoned for a period of 5 years to 10 years and a fine of lot less than 1 crore rupees. Big takeaway number 5, and there have been such actions that have been taken to ensure that no tampering, no exam leaks take place in the future. Action against institutions will also be taken who are involved in committing organized crime. The punishment includes attachment and forfeiture of property, recovery of proportionate cost of examination. And these institutions, what is the definition of this institution? Agencies, associations, businesses, companies other than public authorities are the ones who constitute to be institutions who are involved in committing organized crime. Let's also take a look at a number of these offences, and these number of offences are many in number, and let's go to them point by point. And we have a copy of this act that has already been made part, already been implemented, and here's a look at the unfair means and offences. And if we take a look, there is leakage of question paper or exam key or thereof. So if there is a paper leak or the answer key is leaked, then all these laws, all these punishment apply. Participation in collusion with others to effect leakage of question paper or answer key. There is accessing or taking possession of question paper or optical mark recognition response sheet without any authority leads to punishment being given to individuals, to organizations, to companies and agencies. Providing solution to 1 or more questions by any unauthorized person is also going to bring to fore your involvement in the crime, and therefore punishment will be meted out to you. Directly or indirectly assisting the candidate in any manner unauthorized in public examination, tampering with the examination sheets, answer sheets including the optical mark recognition response sheets, altering the assessment except to correct a bona fide error without any authority, willful violation of norms or standards set up by the central government, tampering with the document necessary for shortlisting candidates, deliberate violation of security measures to facilitate unfair means in conduct of exams, tampering with the computer network or the computer resource or the computer system, manipulation in seating arrangements, allocation of dates, shift for candidates to facilitate the adoption of unfair means in examinations, threatening the life, liberty or wrongfully restraining persons associated with public examination authority or the service provider, creation of fake websites to cheat for monetary gain, conduct of fake examination, issuance of fake admit cards, offering letters to cheat or any kind of a monetary gain is all going to be in the ambit of providing punishment under the act. There is going to be no person or group of persons or institutions which should collude or conspire to facilitate indulgence in any such act. There is also no person who is entrusted or engaged with the work pertaining to the examination shall enter the premises of the examination center to disrupt the conduct of exam. There is no person who is engaged with the duties to conduct the exam before time fixed for opening and distribution of question papers. So that obviously directly pertains to opening and leaking and possession or access of solving or seeking assistance to solve such examination papers. The person authorized is not authorized to share confidential information. The person who is entrusted or engaged with any work pertaining to public examinations such except for where he is authorized in furtherance of his duties must not be opening or distributing question papers. So there, now that we see that there is a list of these offences on violation of all these norms and rules, there is going to be punishment that is going to be meted out to the person, to the organization, to the agency, whosoever is found guilty. Let's start our conversation. Joining me on the telecast is Rohit Jain. Rohit Jain is the managing partner, Singhania and Company. He's a senior lawyer. Thank you, Rohit, for joining us on the telecast. And of course, we have broadly taken a look at what are these punishments and what are these offences for which these punishment will be meted out to the individual. If you could shed light into how this act has been made into a law and in such a short span. Is it possible to do so?
Sure. Thank you, Megha, for inviting me. So I'll just give a background of how the law was passed. So on 6th February this year, the law was passed by the Lok Sabha. Then on 9th February, it was passed by the Rajya Sabha. And then on 12th February this year, it received the assent of the President. The Act received the assent on 12th Feb, but there is a provision in the Act which provided that it will come into force from the date on which the central government notifies it. Now that notification has come yesterday, and the Act has come into force from 21st of June, that is yesterday. Now, as you have summed up that what all activities are covered here, the intent is very clear that to be honest, Indian Penal Code, Prevention of Corruption Act. So the acts are there, the law is there, but the intention is very clear that considering the large number of cases that are coming across in recent years, the government wanted to bring out a law which is focused on it, and which is why this whole process has been brought out. Now, I think the law is quite wide, inclusive, and it's very I think the whole NEET scam and the NTA UGC scam that has kind of I think expedited bringing into force of this act. I think in my personal view, the designated investigating body is still police in the act. Therefore, I feel that though the act has been brought into force, but implementation will again be a challenge.
Okay.
Because the police is already burdened with so many cases that are going on. So it would have been better if a separate special investigating body could have been formed, focused on this. I think that would have been a better process.
Okay. Like you said, this bill has been present in the Lok Sabha, it's been passed in the Rajya Sabha. It's only been notified now after this massive scam has emerged and it's been in the public eye for the past several weeks now. What was stopping the government from implementing the law is the big question everybody will ask.
True. I mean, see, first of all, it's not unusual. We have seen with various laws that, the bill receives the assent of the House and the President. gets enacted, but the government tries to implement it in phases so as to ensure smooth implementation, get the resources ready, get the background, a framework ready for proper implementation. So it's not unusual. Uh,
But do you
Perhaps
think the timing of it is something that is going to be questioned, of course, by the opposition and the students who have suffered?
I mean, see, to be honest, yes. Also, the act is not clear on, whether the exams that have already happened before it is passed will be covered. So, for example, the NEET exam, the UGC exam, which has been under scanner, it's not clear whether they will get covered by this law. So, yes, the questions will be raised that when it was passed in February itself and we are in June. Why did the government take so much time to notify it? Perhaps elections may be a reason where the government was focusing on, and which is why they were waiting for that to get over. But still, yes, questions will certainly be raised, and I mean, rightly so.
Okay. The National Testing Agency is under the scanner. Questions are being raised. There's speculation that there were members from the National Testing Agency that may have themselves been involved in this scam, in the paper leak. And there have been cases after cases, revelations that are pouring in from Bihar and from Jharkhand and from Godhra. So, with this 1,563 students whose exams are going to be taken again tomorrow, is also something that is being questioned by the students. That is being said that why not the entire test be redone, as at this point of time a decision that has been made under the NET UGC. And the second, I think there's a third examination that is right now being cancelled by the government.
Yeah. No, you're absolutely right. In fact, when we had filed, the case before the Supreme Court of India on behalf of Mr. Alak Pandey, I think we've been maintaining from the start that time is of essence. And, the counseling is around the corner with no, I mean, with these issues getting murkier, it really needs to, be clarified on priority. Now, be it about the 1563 students whose grace marks have now been cancelled, and they'll have to sit for another, they have an option to sit for another exam. I mean, similar questions, petitions are being filed by other students who are claiming that they had time loss, etc. So you're right. I mean, these questions are left to be answered, and officials of NTA are coming into the scanner, whether re-need will happen, not happen. See, logistically, 24 lakhs doing a re-need is also not easy. And to be honest, more and more details are coming out that, 50% centers did not even have CCTV cameras. So to rearrange all of it, it's a Herculean task.
Yeah.
In my personal view, re-need looks really tough logistically, but I mean, it can't be ruled out in case if things start getting, proved that yes, there were instances at different centers, then perhaps it may also happen.
Okay, all right. Thank you, Rohit Jain, for joining me on the telecast and sharing your views and explaining to us in detail about this law and what it entails and what are going to be the repercussions of it for those who are involved, who are convicted in the crime of paper leaks and the scam of the NEET exam. All right, now here are the 10 big takeaways from this bill. Number one, the Act pushes stringent action, including jail for students, for parents, for officials, as well as for private entities. Number two, Act brings all offences which are brought under one Act. They are cognizable, they are non-bailable, and they are non-compoundable. Big takeaway number three, the jail term up to 10 years and there is a fine of up to 1 crore, which is the toughest punishment till date. Takeaway number four, private entities involved will lose their properties and pay proportionate cost of examination. Takeaway number five, the exams that are conducted by the UPSC, by the RRB, by the IBPS, the government departments, the NTA and Staff Selection Commission are to be governed by All right, takeaway number six, Failure of reporting the offence will be included as committing the offence itself. Takeaway number 7, officer not below the rank of the DSP or the ACP will investigate these offences. Takeaway number 8, central government will have powers to refer probe to any agency it desires so. Takeaway number 9, proceedings will be initiated if commission is established prima facie. And takeaway number 10, the act will be in addition to, not in derogation of any law, for the time being in force. So now that we have taken a look at these 10 takeaways, I also have with me Ujjwal Nikam. He is the special public prosecutor who joins me on the telecast. Thank you for joining us, sir. And according to you, what are the salient features of this new bill? And do you think it will lead to transparency?
Say, specifically, I must welcome this new bill, because in order to avoid the recurrence of the malpractices in the public examination and to have the transparency, the government of India has taken a very bold decision to introduce this type of bill. Now, the salient feature of this bill is they have defined the various, what is meant by unfair practice, by unfair means, and how the authorities, like the individual authority, as well as the director of an institution, or the person in charge who holds such an examination, will be held responsible. The third important facet of this is that the punishment, that is no doubt is a very severe punishment, as well as the fine which may extend to about 1 crore. I have never come across a huge fine which has been proposed. But why? Why? Because the very purpose of the criminal jurisprudence, that a harsh sentence or fine is recommended only not to punish the very criminal, but to give a strong signal to the like-minded peoples. So here in this case, the new bill, the minimum punishment is not less than 3, which may extend to 5 years also, fine also up to 10 lakhs, and to the director and the person in charge of the institution, the fine goes to up to 1 crore. So basically, they have exhaustively defined what is exactly meant by how the unfair means in the public examination can be prevented. They have given the various definition also, and the important is about the punishment if any person are found guilty of the said offences. Secondly, also the important is that the task of the investigation is being entrusted to such a police officer who is not below the rank of the DYSP, as well as in a metro cities, not below the rank of the Assistant Commissioner of Police.
Okay. Now, do you feel that paper leaks being made into a non-bailable offence will take us towards solving the problem once and for all, and of course be a strong deterrent to those who are aiming to do so?
See, ultimately, the government intention is very transparent and clear to stop the malpractices, and therefore they said that if any person found guilty under this act or offence, there is a prima facie of evidence that he has committed an offence, then it is a non-compoundable and also a cognizable offence. So I firmly believe by making these drastic changes in the so far as to avoid the stoppage of the unfair means, these are the good things that the government has decided to introduce in the bill.
The punishment has been made even more stringent for examination authorities, with double the punishment and fine of up to 1 crore. And you were speaking about this. Do you think this will help tighten them?
See, ultimately, I have already explained you why such type of harsh punishment is normally recommended And the Bible of the criminal law is the criminal jurisprudence. And the criminal jurisprudence says that to give a strong signal to the like-minded peoples in order to avoid the recurrence of such unfair means in the public examination. That is the sole intention, it appears.
Absolutely. Do you think there is a strong message that has now been conveyed to coaching centers as well, who if found guilty would lose their properties and will have to bear the proportional examination costs?
Yes, it will be a strong signal to the coaching institutions, because normally it has been brought on the record also that many persons who are running the coaching classes, they are indulging in such unfair means, and therefore this act has defined different definitions also. Okay, what is meant by the office, controller, director of institution, particularly how the computer's copy also is being made. So they have exhaustively defined the various things. Now we have to give time also that how this act will be implemented. The only thing is that whether the provisions of this is ultra virus, basically the fundamental rights of individual or not. In my opinion, no.
Do you think this law deals with the post-cheating action as well, leading us to find out solutions on how to better our vigilance system?
We had to expect such things, because by making certain deterrent provisions will have some good impact also.
Right. And what would you recommend needs to be added to this law?
I need not add anything, because this is a very exhaustive, they have made it. Only we had to see that how far it stands to the other legal scrutiny, because the sole intention of the government, which has been clearly they have made out in the object and the reasons of the said bill, and the object is the very clear, in order to stop the malpractices in the public examination, and there should not be any scope of concoction of the fabrication also, if this is the sole intention of this bill. Now let us see what happens ultimately in the House.
Okay, all right.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.